All rise. We will away. The International Residual Mechanism for Criminal Tribunals is now in session. Lors ce mécanisme international appelé à exercer la fonction résiduelle de tribunaux pénaux et ouvert. Please be seated.
Registrar, would you please call the case?
Thank you, Your Honor. This is the Arusha branch of the International Residual Mechanism for Criminal Tribunals sitting in The Hague this 6th day of October 2021 in the matter of the prosecutor versus Félicien Kabuga, case number MICT-13-38 PT, Judge Bonomi presiding. Thank you, Your Honor.
Thank you. Good afternoon, everyone. I'm conducting this status conference in my capacity as the presiding and pre-trial judge of the trial chamber assigned to this case. May I now have the appearances for the parties? First of all, the prosecution.
Good afternoon, Your Honour, and to everyone in the courtroom and participating remotely. For the prosecution this afternoon, myself, Rupert Elderkin, to my right, Maria Yakusheva, and our case manager today, Janet Stewart.
Thank you, Mr. Elderkin. And now for the defence.
Good afternoon, Your Honour. The defence team is made up of Professor Jacobs, myself, Emmanuel Altit, Principal Counsel, and Your Honour, I'd like to introduce you to a new member of our team, Ms. Merle, who's sitting to my left.
Mr. Kabuga himself is joining us through a video conference link from the United Nations Detention Unit. Mr. Kabuga, are you able to hear me and to follow the proceedings?
Kabuga urumva President uratwumva
I have no translation of what was just said.
President ati numvise ibyo basemuye.
Well, I shall try again.
Reka nongere mbaze ikibazo Bwana Kabuga. Uwo ni President arabaza ikibazo Bwana Kabuga.
I'm sorry, I do not understand the response.
Ati na n'ubu sindumva igisubizo cya Bwana Kabuga kuko nashakaga kubaza Bwana Kabuga niba ari kutwumva yumva ibivugirwa ahangaha. Bwana Kabuga uratwumva?
Now, can the interpreter assist me with the response?
Your Honour, the English interpreter has not heard anything coming through the French channel and as such is unable to translate into English.
Well, Mr. Kabuga, I am speaking directly to you.
reka nkubaze uwo ni perezida ubaza bwana Kabuga agiye kukubaza ikibazo ese uratwumva
Have you heard my words translated into a language that you understand?
ibyo ndimo kuvuga urabyumva mu rurimi
Well, I can only try once more.
reka nongere ngerageze mbaze bwana Kabuga
Mr. Kabuga, are you hearing my words
Kabuga
translated into a language you understand?
mu kinyarwanda ibyo mvuga barabise kinyarwanda uranyumva
Answer, yes, Your Honour. I do hear you.
urakoze cyane
Now, Mr. Kabuga, it is important that if anything is said which you do not understand clearly, that you draw that to my attention.
ni ngombwa ko mbimenya
Do you understand that?
wanyumvise
Can the interpreter please try that again to ask Mr. Kabuga if he understands that if he has any problem in understanding the proceedings, he has to draw that to my attention.
adasobanura neza bwana kubimenya perezida
Mr. Kabuga, I welcome your presence in these proceedings today, but it is important also that you play your part. So may I please have your reply to this question? Will you draw to my attention any matter that you do not understand as we proceed?
I don't know when it is.
Answer: I did not quite understand.
That you do understand. So if there is anything that is not clear to you, will you please draw that to my attention?
Umva zekubi
Well, I shall try a different approach. Can you tell the court, please, Mr. Kabuga, your full name?
Kabuga. Tubwire
Je mubanza
Answer: Are you putting the question to me? My name is Kabuga, Félicien.
Thank you. Well, I'm satisfied that it is appropriate to continue in your presence and with you participating. Will you please answer in due course any question I put to you? Can I ask the interpreter if that question was translated for Mr. Kabuga?
Answer from the interpreter: Yes, Your Honor, the question was translated for Mr. Kabuga.
Mr. Kabuga, I need to hear from you that you are understanding the words I am speaking. Can you please confirm that to me? Can I again ask if that was interpreted for Mr. Kabuga?
Answer from the interpreter. Yes, Your Honor, that was indeed interpreted for Mr. Kabuga.
I will simply note that you are unresponsive, that you are not responding to the questions put to you, and I shall proceed with the status conference as planned. I will return to you shortly and invite you to make comments.
What? I said,
The interpreter points out that he didn't quite catch what Mr. Kabuga just said. It was inaudible.
Mr. Kabuga, could you repeat that, please? Once again, I note no response, and I intend now to proceed with the status conference. And the first thing I wish to do is cover some procedural developments since we last met and to indicate my ruling on certain pending motions. After the status conference on the 1st of June, the trial chamber issued an order for a pre-trial work plan on the 4th of June, providing specific pre-trial filing deadlines for the prosecution and the defense. Consistent with that order, the prosecution filed a motion for judicial notice of adjudicated facts under Rule 115B on the 16th of August, which the defense largely opposes. The trial chamber has issued its decision in writing today, granting the motion in part, denying it in part, and seeking further submissions from the defense on certain proposed facts that may require to be judicially noticed as facts of common knowledge that are beyond reasonable dispute. On the 21st of August, the prosecution also filed its notice on witness protective measures from prior proceedings and requests therein additional or new protective measures for certain anticipated prosecution witnesses. On 1st September, the defense informally communicated that it did not oppose the prosecution submission and would not be filing a formal response. A written decision on that motion or notice will be issued in due course, probably in the next 2 to 3 weeks. Also, in accordance with the pre-trial work plan, the prosecution filed its pre-trial brief with witness and exhibits lists on the 23rd of August. And then its notice of experts it intends to call on the 30th of August. On 27th September, the defense requested a variation to the pre-trial work plan to allow it to file its responsive pre-trial submissions and its notice on the prosecution expert witnesses by 15th November. The prosecution does not oppose this request, which I now grant. No written decision will be issued. In the same 27 September filing, the defense has also requested that it be allowed to file its notice of alibi and special defenses on a date to be determined later. The basis of this request is rooted in difficulties the defense is experiencing in communicating with the accused about the case based on his current health condition. The prosecution is amenable to a delay, but opposes an open-ended deadline. I will amend the pre-trial work plan to allow the defense to file its notice of alibi and special defenses by 15 November. No written decision will be issued. However, the issue may be revisited by the defense as the deadline approaches. And a further extension may be considered if the circumstances warrant it. The trial chamber is currently closely scrutinizing the prosecution's proposed experts and their anticipated evidence. The chamber would very much like the prosecution to consider reducing that list and focusing on the specific expert evidence, if any, that is necessary for this particular case. Yesterday, I had an informal meeting with both parties in preparation for today's hearing. A number of matters were discussed. On reflection, I realize that it would have been valuable to discuss the issue of the prosecution's proposed experts. I shall be meeting the parties again tomorrow for further discussions related to the management of the case. I invite counsel on both sides to be prepared to discuss this issue further at that meeting. Finally, in anticipation of filing a public redacted version of its pre-trial brief, the prosecution filed a confidential and ex parte motion on 1st October. That motion seeks variation of an order issued on the 15th of March 2011, which required that special depositions to preserve evidence in the case against Mr. Kabuga be conducted confidentially. Evidence gathered through special depositions while Mr. Kabuga was a fugitive no longer needs to be confidential in light of his arrest, with the exception, of course, of witness protection matters. Consequently, and pursuant to Rules 55 and 86K, I grant the prosecution request to vary the order of 15 March 2011 as follows. The parties may refer publicly to evidence taken during special depositions, so long as doing so does not violate existing decisions or orders that prevent the disclosure of the identity of protected witnesses. Likewise, if information or evidence gathered during the special depositions has been ordered confidential for reasons other than that it was presented during confidential special deposition proceedings, the parties must comply with such orders. No written decision will be issued. Turning now to Mr. Kabuga's health. The trial chamber has received regular medical reports from the detention unit medical officer since Mr. Kabuga's initial appearance in November 2020. Additionally, on 15 April, the trial chamber ordered that an independent medical expert examine Mr. Kabuga and submit a detailed report on issues relevant to his fitness to travel to Arusha and to stand trial. On 18th June, the trial chamber received the report from the independent medical expert, which the parties were asked to comment on by way of order issued on the 24th of June. In view of the submissions received and additional medical information received from the registry, the trial chamber on 13th August ordered the independent medical expert to conduct further evaluations of Mr. Kabuga and to file another report with additional information necessary for the trial chamber to enable it to provide a reasoned decision on the matter of Mr. Kabuga's health and its impact on the case. The trial chamber actually ordered that report to be filed by the 28th of September. However, unforeseen circumstances caused delay in the scheduling of a medical procedure for Mr. Kabuga that was originally planned to occur prior to the independent medical experts' further evaluations. And that has prevented meaningful completion of these evaluations prior to this hearing. The trial chamber intends to set a new deadline for this report after further consultations with the registry as to when such evaluations may occur. Now, Mr. Kabuga, I turn again to you. I would like you to tell me about any matter that you wish to raise with this court today. About the case, about the conditions of your detention, about the care you're receiving, and about any other matter you consider important. is there any matter you wish to raise with me?
ibibazo
nuko nashaka altitude ntabwo mushaka
Is there interpretation of that answer?
Mr. Kabuga said that he does not want Mr. Altit. Mr. Kabuga answered that he does not want Maître Altit.
répond que il ne veut pas être altit.
Kabuga, I hear your comment that you do not wish to be represented by Maître Altit. However, for today's purposes, I have to tell you that he has been assigned as your representative and is acting in your interests and has been, as far as the trial chamber can tell, throughout the proceedings.
nkurikije uko urugereko rubibona akunganira neza. L'interprète de la cabine kinyarwanda dit que
The interpreter from the Kinyarwanda booth says that Mr. Kabuga answered.
demander à Kabuga de reprendre sa réponse.
And Mr. Kabuga is being asked to repeat his answer.
Mr. Kabuga, do you wish to repeat your answer since it was not understood?
kubera ko umusemuzi
navuze ko nashaka altitude kubera ko
je vous disais donc que
Answer. I was saying that I do not wish to be represented by Maître Altit. And that is because he does not share with us his submissions and arguments that he presents before this trial chamber.
I have noted what you have said, and I and my colleagues will consider your statement in due course. Meanwhile, since we are here and you are represented by assignment of Mr. Altit on your behalf, I intend to continue with the status conference, and I do need his assistance, and the court recognizes him as your representative and recognizes his presence here today on your behalf. Now, is there any other matter that you wish to raise with me?
L'interprète doit
Answer. The Kinyarwanda interpreter did not catch what was said. The interpreter for Kinyarwanda did not correctly hear the answer given by Mr. Kabuga.
Mr. Kabuga, I shall ask that question once more. Is there anything else you wish to raise with me?
The Kinyarwanda interpreter did not hear Mr. Kabuga's answer. However, I can inform you that I do not wish to be represented by Mr. Altit because he does not submit to us the reports that he puts before the trial chamber.
Mr. Kabuga, I have already noted that. What I want to know now is whether there is any other matter that you wish to raise with me.
mbere nacyumvise neza hari ibindi bibazo
I shall note your lack of response as indicating that there is no such matter, and I will proceed now to ask Mr. Altit if there is any matter he wishes to raise relevant to the exercise of preparing for trial in due course. Mr. Altit.
Mr. Altit. Thank you, Your Honour. As regards the disclosures, I will not go back over what has already been said. There is just one point that I'd like to raise that I think is worth raising because it could affect the organisation of work. And that's the question of the admission of certain prior statements by certain witnesses. And this was referred to in the June 2021 submission in the following way. The 110 witnesses on the list of witnesses, of them, only 48 will be appearing in person, viva voce, including the 3 proposed experts. The prosecution is proposing to ask that some 36 witnesses be admitted under Rule 110 As for the following 11 witnesses, it is asked that they testify. Then there are 16 witnesses who have passed away, and it's asked that their statements, their testimonies be admitted under Rule 112. It's understood that the prosecutor submitted a number of motions in order to have the prior statements of over half of these witnesses be admitted, and the defense counsel would like to stress here that it will have to answer those motions in order to challenge the admissibility of certain of these statements, and this before the chamber takes a decision. So that is as regards what the prosecutor has transmitted to us as regards the work plan that you referred to, Your Honor. Then I have other points as well that I'd like to raise.
First of all, Mr. Elderkin, perhaps you can indicate the steps that have been taken already to deal with these two categories of witnesses that were referred to.
Your Honour, following the transcript in English, I read MICT-13-38's statement. It is understood that the prosecutor submitted, past tense, a number of motions. I should clarify, in case there was any misunderstanding during yesterday's informal meeting when this subject of the mode of presentation of the prosecution's proposed witness evidence was discussed. I hopefully was clear in saying that we are in the process of preparing such motions. Those will be submitted. Of course, we recognise that it rests in the Chamber's hands to determine whether those proposed modes of entering in written testimony as evidence will be accepted according to the rules and the purposes for which the different rules serve in relation to the Rule 110 witnesses and 112 witnesses in particular. Of course, for the Rule 111 witnesses, although their direct evidence comes in on paper, they are being proposed to appear for cross-examination. But I would reassure MICT-13 that those submissions have not yet been filed, and of course there will be ample opportunity for there to be a challenge to any such witness according to the defence's assessment.
Well, thank you, Mr. Elderkin. I note the position, but it is important, I think, to reflect on the number of witnesses involved in this, and therefore it's reassuring to note that your preparations are underway, and the Chamber would hope that you could submit these motions as soon as possible. Obviously, it's helpful if at least some come together rather than all individually. And I would encourage you to submit these as and when you have a group that you're in a position to submit to the Chamber, because I anticipate a fair bit of work required in light of what you request, and bearing in mind the time that is necessary to allow the defence to answer.
That is understood, Your Honour. Thank you.
Thank you. So, Mr. Altit, I note the remarks you've made, and I note what the prosecutor has said in response. I'm content to rely on both of you demonstrating common sense in how you approach this. And it's reassuring that both of you are well aware that this is a substantial exercise and needs to be engaged in fairly soon. Now, what else do you have for me, Mr. Altit?
Maître Altit. Your Honour, perhaps I could say something about the work of Defence Counsel, because There's an awful lot of work involved. And obviously, the question for us is to examine each piece of evidence in the context of the overall context of the evidence, in order to have a general overview of evidence as a whole. We're focusing on the process, on this process for the moment, in order to try to streamline work as much as possible, so that we can move ahead as rationally and as efficiently as possible. And once we will have finished that, we will then be able to move on to the inquiries as regards the analysis that we've made of all of the evidence as a whole, as a complete set of different elements. I can give you an overview of what the Defense Council is doing here and now. It's constant work involving analysis of each piece of evidence that we have received from the prosecutor. So, having clarified that at the outset, it might perhaps be useful to tell you and also to tell the prosecutor that at this stage in our analysis, and it's possible that things change depending on how work evolves, but at this stage in the analysis, we have not identified any elements or aspects of the prosecution that we will not be discussing. In other words, to put it clearly, it is likely that we will discuss all of the elements in the indictment. That is to tell you what our position is and to facilitate things from the point of view of prosecution, but that is the current status, and obviously things will have to be checked as work moves forward. Your Honour, it might be a good idea to come to the question of the state of health. And I would like to say that as we see things, Félicien Kabuga's health is extremely worrying. He strikes us as being very weak indeed. But these are questions that I'd like to deal with in private session, if I may.
Before I react to your request to have a private session, can I ask if you wish to make any comment on what Mr. Kabuga has said today?
Maître Altit. Your Honour, it's obviously a very delicate situation. I think that our request to withdraw was public. Well, I would say not the content of our request, but the fact that we asked to withdraw was public. So there's nothing new on that score. I can tell you that we're doing our utmost to defend Mr. Kabuga's interests. And as regards the members of my team, they are showing great devotion, putting a lot of energy and effort into this. They are working extremely hard, as well as they can, and certainly extremely professionally.
That's the case. I'm just a little more concerned about the specific comment that was made about unwillingness to share submissions that you intend to make on his behalf.
Maître Altit. Obviously, I will answer that question, Your Honour. I think that this will involve dealing with sensitive issues, and it would be better here to go into private session.
Well, I'll grant that request in a moment, but it may be that following what you have to say, I decide that there are elements that ought to be public, and we can deal with that in due course. Before then going into private session, I do want to make one other thing very clear, that the trial chamber is extremely concerned itself about Mr. Kabuga's health and the situation in which we find him. And it was, as I indicated earlier, welcome that he was able to attend today and have the opportunity to comment as he considered appropriate. There are now obviously more specific issues related to health that have to be addressed, and for that purpose we will go into private session.
We're back in open session, Your Honor.
Thank you. While the court was in private session, Maître Altit explained his concerns in relation to the health of Mr. Kabuga and explained also his practice in sharing material and in sharing arguments in the case with his client, as that relationship has existed from the outset of these proceedings. And the court is content that the matter has been dealt with as far as I, as pre-trial judge, can deal with it at this stage. Now, Mr. Altit, are there other matters you want to raise openly?
Maître Altit. No, thank you, Your Honour.
Now, Mr. Elderkin, are there any issues for you?
Your Honour, this is a very small point, but in the vein of the beginning of the status conference and running through some of the pre-trial administration and housekeeping matters, it occurred to me that in the pre-trial work plan, apart from those items already completed, the prosecution's pre-trial filings, and of course the defence submissions, which we have no problem with, the extension of time granted, there still remains, I think, on the list for October the 18th, the possibility of joint submission by the parties on agreed facts. We have been in communication, and so far there is nothing to offer on that front. It does occur to me that given the movement of the other deadlines for the defence, there may be the potential for an opportunity to identify areas of agreement during that further period after October the 18th. I would simply make a suggestion that it could be of interest should it allow for any agreement to be reached, of course, without prejudicing or prejudging any position taken by the defence. Apart from that, I don't think I have anything else to offer, Your Honour.
Well, I think you can take it, Mr. Elderkin, that if the deadline passes and at a later date you come forward with a joint agreement on facts, you're more likely to be welcomed with open arms than dismissed. So it's reassuring to hear that your efforts to reach agreement will continue, but you've obviously heard the position that Mr. Altit takes for the moment on that matter, and therefore I won't be holding my breath on written agreements by the 18th of October. Mr. Kabuga, that concludes the proceedings for today. I will close by simply indicating to you that I am happy to accept Mr. Altit's reassurance that he has been and continues to endeavour to share everything with you that he intends to submit to the court. For that reason, nothing has occurred here that persuades me that I should invite the registrar to reconsider his assignment. I'm content that matters should continue at present, and I would encourage you to give your full cooperation to Maître Altit in your own interests. Like him, the court hopes very much that your condition will stabilize and improve. And I simply urge you to recognize the efforts he has been making on your behalf and to recognize that it is in your interests to give him your full cooperation. I will allow you the final word. Is there anything else you wish to say?
ariko mbere yuko wifuza kutubwira
Attitude nuko atakora na atakora.
Answer. In my opinion, Maître Altit is not doing a great deal. When we put certain questions to him, he does not answer. That is the reason why we wanted to change counsel.
Mr. Kabuga, I have taken note of all you have said. I now declare the status conference concluded. The court will adjourn.
All rise, we will away.